Former University of Michigan head coach Sherrone Moore expected in court this hour for an initial court appearance for an alleged assault earlier this week. And this has taken the headlines. Boy, oh boy, this guy had it all. Sherrone Moore, he was fired as Michigan's head coach earlier this week for what the school is calling an inappropriate relationship with a staff member. Hours after he was fired, the married father of three was arrested and taken into police custody. Newly released dispatcher audio details the investigation into the alleged assault involving Moore. Take a listen.
Subject just called the caller to remove the mail at the location and the house attacking her. He's been stalking her for months. They call S1's wife in Ann Arbor saying that the subject is suicidal. Reference losing his job today.
According to wife and S1's mother, he is at an unknown parking lot somewhere. We're attempting to have wife contact him.
The Associated Press is reporting that the charging documents have been filed. 3 potential felonies, home invasion. They're all home invasion and stalking related. And those dispatchers were heard saying that the subject, Sherrone Moore, was suicidal, that he lost his job today. His wife, because he was, this guy's married, he's got 3 kids. He was at one point with his wife. She was so concerned because he left apparently with some knives that he was suicidal. She called authorities. This was a massive collapse. This is a guy that was getting ready to coach the Michigan Wolverines in a bowl game coming up. He had just had a press conference the day before, and then he lost his job, and then he presumably lost his family because it came out that he was having this affair. And now, at least for now, he lost his freedom for a night in jail because he is being charged with stalking and home invasion. Let's bring in, we're waiting for this hearing to get underway. It's an initial court appearance. Will be likely arraigned. There are cameras there, and our team is there. So we're going to go into that Michigan courtroom as soon as they get underway. We have the feed up, so as soon as we go, we'll head there. Philip Dubé is with us. He's former public defender for Los Angeles County. Talk about a fall from grace. This is spiraling, and it's just over a very short amount of time. Talk about these potential charges that he is facing in terms of seriousness and what kind of situation he's in.
Well, I'm not buying the home invasion aspect of it, Ted, and here's why. Typically, we associate home invasion with basically a form of residential robbery. And robbery really means is that you're taking property from somebody else by force or threat of force, as opposed to just barging in wanting to have a discussion. If you're barging in to want to hit somebody, who knows, maybe even stab them or engage in some type of assaultive conduct, that's a form of burglary. Entering a home to either steal or to commit a felony is the textbook definition of residential burglary. Now, given that, it still doesn't give him a pass to go over there and do that. I mean, if anything, he's supposed to set an example. But given the relationship that he had with this young staffer, he probably figured he could just go over there and throw his weight and his might around, and she would just kiss the ring to keep her job. Well, she did this to the wrong person, and obviously her family was there and called the cops. So it's not looking good for him, and he's going down.
Okay, the judge is just taking the bench here, and I believe we have audio, so let's listen in.
Send that through, Paul. We are now calling case number 25F12175. This is the people of the state of Michigan versus Sherrone Banfield Moore. Mr. Simon. Appearances.
Thank you, Your Honor. Good afternoon. Katie Rizmersky, First Assistant Prosecutor for the Special Victims Unit for the People.
Hey, Your Honor, Joe Simon on behalf of Mr. Moore.
That's the charges, sir.
We waive formal reading of the complaint. Your Honor, stand mute to the charges.
Formal reading having been waived, plea of mute will be entered on your client's behalf. Simon, make your bond argument now or reserve?
Your Honor, I think the people want to make a presentation, and I'll go after that if that's okay.
All right, Ms. Wisniewski.
Your Honor, thank you very much. I appreciate that. Mr. Simon. And thank you for the opportunity to be heard. As the court is well aware, this is not a series of offenses in Michigan that allow you to deny bond. We're certainly not asking for that. This is a felony of home invasion third degree, misdemeanor stalking, and misdemeanor entry without permission. Your Honor, we are asking for a $25,000 cash or surety bond in light of the fact that we cannot ask for you to deny bond. I get that he is a man of means, and so this is a bit of a nominal monetary ask, but quite frankly, it would be an ask that I would make for any defendant charged with these offenses before you. So what strikes me as perhaps more important in this scenario are conditions that I would like to ask for. Because of course, as you know, Your Honor, you're tasked with trying to make sure that he reappears, but also the safety of the public and this victim in particular. So Judge, in addition to an ask for a $25,000 cash or surety, we are asking, should he post that, should you impose that, we are asking that you order that he undergo a mental health evaluation. We are asking that you order him to submit to a GPS tether and that there be a no-go to this victim's residence or place of employment. Ask that you order that there be no contact with her whatsoever in any means, any fashion, direct or indirect, that there be no stalking behavior of any kind, that he be ordered to surrender any and all weapons, further that he be ordered to surrender his passport. Judge, the reason, Your Honor, the reason we make those requests is in light of the factual scenario that gives rise to these charges. My best understanding from a thorough review of the police report and as much body-worn camera as I've had an opportunity to review is that I understand that our victim broke up, they had an intimate relationship for a number of years, defendant and victim, that our victim broke up with this defendant on Monday morning early, that there continued to be defendant making numerous phone calls and sending numerous texts from that time moving forward that she did not answer, did not respond to, and did not want. That eventually she presented herself to the University of Michigan, cooperated in some form of investigation there. As we all now know, defendant was at some point on Wednesday afternoon fired from his employment. He then, at some point soon thereafter, came to her apartment in the address that is alleged in the complaint, barged his way into that apartment, immediately then proceeded to a kitchen drawer, grabbed several butter knives and a pair of kitchen scissors, and began to threaten his own life. I'm going to kill myself. I'm going to make you watch. My blood is on your hands. You ruined my life. And a series of very, very threatening, intimidating, terrifying, quite frankly, statements and behaviors there in that apartment. It was only then, Your Honor, when the victim, she called her attorney and then at some point indicated she was going to call the police, and then he left. And so, Your Honor, while I understand that there isn't evidence to suggest that he directly threatened the victim with any of those implements that I've indicated, the totality of the behavior is highly threatening and highly intimidating. She was terrorized, Your Honor. And in light of the totality of all of those circumstances, we consider the defendant to be a risk to public safety, a risk to this victim, and it is for those reasons that we are asking for those specific conditions. I am more than happy to answer any other questions that the court may have or give you further information. I appreciate the opportunity. Thank you, Judge.
Mr. Simon, as to bond.
Your Honor, let me start at the end where the people ended. In terms of risk to public safety, my client's 39 years old with zero prior criminal history, zero prior contact with the criminal justice system in any fashion. The threat to public safety argument by these charges, maybe that's the point, but there's no evidence to suggest that he's a threat to public safety. The next thing is that the people referenced the court rule that I want to come back to, that you can't deny bond in a situation like this, and they referenced something else that I want to come back to, which is the fact that they reviewed thoroughly the police report. And they referenced something else that I want to come back to, which is the fact that they reviewed thoroughly the police report and they reviewed thoroughly the body cam. I've had none of that opportunity. And that's too early for that in the proceedings. So when people come in here and make factual representations, although I trust Ms. Rizmirski very much as an officer of the court, I have no ability to respond to those factual representations. So here's what I'm going to ask the court. The monetary bond component, the two considerations by court rule are my client will appear. Let me speak to that. He's got a home here. His family is here. He's got ties to our community. He's retained a local counsel here. The second thing is that my client is not otherwise a danger to the public or danger to the complainant. There are that is why monetary components are requested, but there are other measures to address them. For example, the request for a GPS tether, that was an expected request. My client will gladly comply with that request. The second thing is my client having no contact. Certainly, we have no objection to that order, and my client would be at his own peril if he were to violate that. His bond would be summarily revoked. In terms of surrendering the transport or passport, Your Honor, there's no really indication that he is a flight risk. My client has those established ties that I talked about. But in addition to that, Your Honor, he would have an order from the court, like everyone else does, that there would be no leaving the state and alone the country without permission of the court, and he would certainly abide by that. Your Honor, with respect to the request for a mental health evaluation, I will represent a few things that are my understanding, again, without being privileged to have reviewed discovery yet. My understanding is that following his arrest, my client was taken to the St. Joseph Mercy Health System for an evaluation, a mental health evaluation. My understanding is following that evaluation, he was not turned over for a commitment, but instead turned back over to law enforcement for lodging. That's where he's been in Washington County Jail since. I can also tell the court that the community mental health department saw my client yesterday for an evaluation as well without any further recommendation. If you make that a condition of bond, I can tell the court that he goes to a mental health evaluation. He will absolutely comply and follow any aftercare recommendation. Lastly, Your Honor, with respect to the bond amount. I forgot to speak about weapons. He has no weapons, but he'll surrender. If you order that he surrender any weapons that he doesn't have, he'll be glad to comply with that condition. With respect to the bond amount, Your Honor, in a case like this, with charges like this, in a normal circumstance, we'd be requesting a personal recognizance bond and frankly expecting the court to order it. We all know this is not our ordinary circumstance. It's not an insignificant amount of money to anyone. And I ask that the court set the bond amount to the principles, not of my client's bank account, but to the principles of the charges and to the principles of the court rule. Therefore, I'm requesting that if the court orders a monetary component at all, that it be with a $25,000 10% privilege. And also, Your Honor, if my client is to order to a GPS tether, things have to happen pretty significantly to try to get that in place in time for what we hope to be as released today. Thank you.
Mr. Moore, could you state your name, please?
Sherrone Moore.
Sir, you are not to use alcohol, marijuana, or any other controlled substance that is not prescribed to you. You are not to possess or purchase a firearm or any other dangerous weapon. You are not to engage in criminal conduct of any kind whatsoever. You may not leave the state of Michigan without permission of the court. Prior to your release, you will be placed on a GPS tether. You will not be released before that GPS tether is placed upon you. You must continue all mental health treatment as a condition of your bond. The named victim in this case will not be placed on the record. You may not have contact with that individual. That means no calling, no writing, no video chatting, no texting, no emailing, or any other form of contact the human mind can possibly fathom. No one in the world thinks that this person is going to reach out to you. Should they do so, and again, no one thinks that they're going to, you may not reply in any form or fashion. The named victim's address will not be placed on the record, but you may not go to that location for any reason whatsoever. Are we understood on the no contact and no go to, sir?
Yes, Your Honor.
If you have any questions about that, you have a good attorney, simply ask them. You understand?
Yes, Your Honor.
Bond will be set in the amount of $25,000 cash surety, as requested by the prosecution's office. The court does not determine innocence or guilt. This court determines flight risk and community safety. The court finds with these conditions in place, it has been met. Mr. Simon, we are setting probable cause conference at this time for January 8th due to the holidays and scheduling. Is that a good court date for you?
Your Honor, my client will waive his right to have that next court appearance within 14 days. I've discussed that with him. I also tried to coordinate calendars with Ms. Wisniewski. In support of that, I think we're both available on January 22nd, if the court would order that. And I'll add one more thing for the record in support of that. I understand there is continuing investigation. So in addition to the discovery I don't yet have, there may be even more. So
it will be January 26th, 2020.
22nd, 15, 22nd,
22nd, Thursday.
January 22nd, then. January 22nd, 2026, 9 a.m., 14A1 District Court, Courtroom C. That will be in person. Sir, do not violate these bond conditions. Follow all orders of the court. Stay in contact with your lawyer. That concludes this hearing.
Thank you very much.
Okay, hearing is over. We'll get a break. We'll talk about what we just watched and what's happened, what will happen next to the former head coach of the University of Michigan, now in a jumpsuit appearing via WebEx from a jail. Plus, Walsh, the jury, almost up to an hour. Stay with us.
The disappearance of Anna Walsh.
Her husband now charged with her murder.
All eyes on this accused killer.
The disappearance of Anna Walsh murder trial. Live coverage today on Court TV.
Tonight on Closing Arguments, Brian Walsh's fate now rests in the hands of 12 jurors. We're live with every development as deliberations get underway.
Closing Arguments with Vinnie Politan tonight at 8, 7 Central, only on Court TV.
Welcome back to Court TV Live. We just watched the initial appearance for the former head coach of the University of Michigan. Just earlier this week, he had a press conference talking about how his team was ready for their bowl appearance coming up New Year's Day. And now Sherrone Moore is finding himself in the criminal justice system, facing multiple charges after an incident that took place at a home. And according to the prosecution, it was the home of a person that he had had an intimate relationship for years. And it was recently, she had recently broken it off. And he apparently didn't want that to happen. She went to the University of Michigan. He lost his job, and now here we are. There's his lawyer, who we just watched arguing in court, had a few things to say outside of the courthouse. Let's listen.
Sherrone Moore will be posting bond today.
I expect that.
Do you know where he's going to be able to stay after this? Is he going to be able to go home?
I'm just going to not answer that question, but he'll be in the community.
Tell us about this. What's the mood of your client right now?
Listen, that is something that I will also not comment on, but I will say you heard that there was a condition of bond for him to have mental health counseling, and we expect that too. Okay?
Do you have any comment on the allegations?
None. And I said in court, I've not seen a police report. I've not seen any other discovery. It would be irresponsible to comment, so I won't.
How's he doing mentally? Is he saying anything?
Yeah, so I'm, again, not going to comment on that. Thank you very much, but I do need to get through you guys. Okay. Thank you.
Okay, obviously intense interest there in the state of Michigan and across the country in this case. The lawyer attacked right outside the courthouse, or courtroom, not even the courthouse. He got 1 foot out of the courtroom and boom, the cameras were right there because this is such an extraordinary story. People that follow college football know Sherrone Moore. They know him well. He took over for Jim Harbaugh after they won the national championship, and he was going to be making $13 million next year, Philip DeBay, and that is not going to happen. Michigan fired him for cause, meaning, of course, he does not get that last year, if indeed that holds up. Overall thoughts on what you heard in the proceeding, what's he facing here?
Well, first of all, he has almost a $14 million buyout clause in the contract, but that's assuming he's fired without cause. So let me tell you what I think the issue is going to be here. You have sort of two buckets of legal problems, the labor aspect and, of course, the criminal side. Let's start with criminal. Criminally, the $25,000 bail really is, I mean, to a multimillionaire, is like bus fare. It's nothing. He'll be able to post that in minutes and he'll be out. And I don't know if he's going back home. I sincerely doubt it because I suspect trouble in paradise given the relationship with the staffer. Now, having said that, after listening to the facts as presented during arraignment, I got to tell you, Ted, I fall prey sometimes to media accounts. I thought he went over there and was making threats toward the young lady. As it turns out, he's threatening to kill himself with her butter knife. So it's one thing if he's engaging in assaultive conduct to the inhabitants of the home, but no, he was threatening harm to himself. So clearly there's a mental health breakdown and there was some kind of a psychotic break and he needed to be seen. So the question then becomes, is that a crime? Well, in the state of Michigan, it is not a crime to commit suicide. In fact, it's not even a crime to attempt suicide. And I'm not even sure it is considered burglary to go into someone's home and threaten suicide. So what do you really have at most? Maybe a trespass. And I'm not sure if it's even a trespass if they let him in. So then the analysis goes to the civil arena, the labor aspect. And depending on what the policies are of the college and university, he could be in violation of their charter and their agreement that they have with the school not to engage in dating relationships, particularly given the power dynamic between supervisors and lower level staffers. And that could be a per se violation of their policy. But let's just pretend there is no policy. Well, then you look to state law. And typically, coworkers are allowed to date. Supervisors can date subordinates. I think where it starts to cross a line is if the dating relationship starts to disrupt working operations and business operations. If it starts rising to that level, then certainly the employer can step in and tell them either, look, if you're going to date, you cannot bring this drama into the workplace or we're going to have to let you go. And then if it persists, they can certainly let them go. But I think absent some proof of disruption in the workplace itself, it may be premature to be firing him. And I do predict there will be some litigation on the contract.
I mean, there's going to be a behavior clause in a contract of that magnitude for someone in his position. And he allegedly is having this affair with his direct subordinate, his basically assistant. And if she went to them and said, listen, this dude will not leave me alone. I tried to break up with him and he's badgering me. Then you would think that because they came out very forceful. The University of Michigan said, we're done. You and what you did here has no place here in Michigan. So you're right. That's going to play itself out the way it plays itself out. If he wasn't the head coach of the University of Michigan, at the end of the day, would these charges be dropped likely at the end in a few weeks, months? Or how does his celebrity hurt him possibly as we move forward to the way you describe this? It sounds like a guy who was desperate. His world has just crumbled and he had a mental breakdown.
Yeah, I don't think the celebrity hurts him. I actually think it's helping him because as the facts start coming out, he looks kind of human. if you really think about it, it looks as if he was just on the verge of a breakdown, that he wasn't homicidal, he wasn't assaultive in any way, he certainly wasn't making threats to others. If anything, he was a threat of harm to self. And if that's the case, then he becomes a sympathetic figure because the man needs help. That's ultimately what it's about. You don't want anybody to do harm to themselves, and you want them to get the help that they need, be it for medication, behavioral therapy, injections, or maybe he needs to be in a hospital setting where he can be seen for an extended period of time to get him stable and calm. Because just releasing him on $25,000 bond on a promise to appear might not be enough to kind of subdue him and keep him calm. There should have been some evidence presented that he's on appropriate sedatives and medication to treat him to therapeutic levels. Otherwise, he could, in theory, be a danger, not so much to the community, but to this young lady again. And we certainly don't want to see that. Because then, if you really think about it, the university could be on the hook. And yes, on threat of harm to himself as well.
Yeah. All right. He'll be back in court January 22nd at 9 a.m. and we'll see how this progresses. But a fall from grace for sure for Sherrone Moore, the former University of Michigan head football coach.